joining us from different parts of the world. Welcome to our webinar on the Taliban's Criminal Code and Normalization of Oppression. I'm Watfa Tayyib. I'm very pleased to moderate today's session. And I would like to thank Froggy for convening this timely webinar, and also special thanks to our distinguished panelists, speakers, to joining us and bringing their expertise to the panel and to today's critical discussion. As you all know, on 4th of January 2026, the Taliban put into effect a new criminal code which arranged across 10 chapters, 3 sections, and 119 articles. It was introduced without any public debate, any legislative review, and it now shapes the day-to-day life in Afghanistan, such as arrest, belief, detention, family life, punishment, and public spaces, even speech in Afghanistan. So this code doesn't appear from nowhere and in isolation. It somehow formalizes what the decrees began since 2021, which there were lots of ban on women's education and work, expanding morality policing and public punishment, and shrinking space for civil society. So the big question for this panel today is that whether this code promotes justice or protect justice, or it somehow reorganizes a society where there is fair hierarchy and control. So our speakers will analyze this code through two different lenses. One is the Islamic principles and the proper exercise of legal authority within Islamic jurisprudence, and secondly, through international legal obligations and relevant conventions. So our speakers today are Dr. Noor Rufaya Bilyuzem, Islamic scholar from Indonesia, Dr. Bashir Ansari, Islamic scholar, Afghanistan, Muhammad Farid Hamidi, former Attorney General of Afghanistan, Mustafa Akyol, Senior Fellow on Islam and Modernity, Cato Institute, Muhammad Tariq Osman, Deputy of Afghanistan Scholars Research Association, and Ms. Nargis Nahan, former Minister of Mines and founder of Agir. I would like to begin by Ms. Nahan and ask her to offer an opening remark of a wider context, why this code matters now, how does it, how does it about the broader context of the Taliban governing system, and why the debates about this matters now more than every time. Thank you very much. Floor is yours.
Thank you very much, Outfajan. Can you hear me well?
Yes.
Okay, great. Distinguished delegates, excellencies, colleagues, ladies and gentlemen, allow me first to express my sincere appreciation to all distinguished speakers and participants of today's webinar for joining this very important and engaging discussion, and to my colleagues at Faragir for hosting this timely and necessary discussion. Dear colleagues, over the past 4.5 years, Afghanistan has become a painful symbol of the failure of the international system and the Organization of Islamic Cooperation to protect those most at risk. Since Taliban seized power on August 15, 2021, we have witnessed the systematic dismantling of human rights, targeting women, religious and ethnic minorities, and the steady collapse of accountability in Afghanistan. What began as a series of decrees has now evolved into a fully institutionalized architecture of repression in Afghanistan. In just 4.5 years, more than 100 edicts have directly targeted the dignity, autonomy, and fundamental freedom of people, particularly of women in Afghanistan. Within the few weeks of taking power, girls were banned from education beyond grade 6. Women were prohibited from work, restricted in movement through Muharram requirements. buried from parks, gyms, and public life, and excluded from civic participation. Ministry of Women's Affairs, Human Rights Commission, and shelters, all those institutions that were providing protection for women were shut down. In just 4.5 years, more than 100 edicts have directly targeted the dignity, autonomy, and fundamental freedom of people of Afghanistan, particularly of women and girls. In June 2024, the Taliban adopted the Promotion of Virtue and Prevention of Vice law, institutionalizing public repression and gender apartheid in their system of governance. Now, on January 4, 2026, the Taliban issued the Criminal Procedure Code for courts, which lacks both legal and moral legitimacy, as mentioned by Ms. Tayyib. It is adopted without public consultation, without constitutional foundation, and without oversight from an independent judiciary. It transforms courts into an instrument of ideological enforcement rather than guardians of justice. While every provision in the code is deeply concerning, allow me to highlight just a few critical points. First, it dismantles due process by replacing independent investigation with confession and testimony as a primary evidence, opening the door to torture and coerced admissions. Second, it divides society into hierarchical classes, clergy, elites, middle, and lower classes, assigning different punishment for the same offense. This codified inequality violates the most basic principle of equality before the law. Third, it codifies religious discrimination by defining Muslims exclusively according to Hanafi school and labeling others as heretical, exposing religious minorities to persecution and exclusion. Fourth, it encourages gender repression by reducing domestic violence to a minor offense, punishable only in case of excessive injury, while absolutely ignoring the psychological and sexual abuse, effectively normalizing violence against women. Fifth and final, it criminalizes dissent, grant judges unchecked discretion to punish mockery, and oblige citizens to inform on one another, extinguishing what little civic space remains in Afghanistan. Dear colleagues, this code is designed to cement impunity. If left unchallenged, this framework will normalize discrimination, repression, and extremism. It will further fragment Afghanistan's social fabric through sectarian, ethnical, and classical divisions and further isolate our people. Today, someone from Bamiyan province informed us that just in few days, 62 people are being detained by the Taliban based on this code. In the past 4 years, we have witnessed that whatever is happening in Afghanistan is having its consequences in the region and beyond. We witnessed the deterioration of security in Pakistan, and just yesterday we read about the tragic suicide blast in Russia, and so many more incidents that are not yet made public. Furthermore, what the Taliban are doing in the name of Sharia is really damaging the image of Islam. When injustice is carried out in the name of religion, it fuels criticism, confusion, and alienation, particularly among the young generations searching for faith rooted in justice, dignity, and compassion. Dear colleagues, we cannot remain silent. Silence in the face of repression is not neutrality, it's complicity. Today's webinars bring together respected Islamic scholars from Afghanistan, Pakistan, Turkey, and Indonesia. We hope to create a meaningful space for dialogue between defenders of human rights and Islamic scholars. We hope our distinguished speakers, including Afghanistan former Attorney General, will critically examine this so-called Criminal Procedure Code from both legal and Islamic perspective for our participants. Our aim is clear: to bridge the gap between civil society and religious scholars and experts, to build principled alliances, and to affirm that justice for the people of Afghanistan, especially for women, and the integrity of Islam are not opposing causes, but shared responsibility. Today's webinar is part of a process that Faragir has initiated since 1 year for engaging Islamic scholars around the globe in support of people of Afghanistan. We hope to continue and expand these engagement as changing the situation in Afghanistan is more a responsibility of all of us. Thank you.
Thank you very much, Ms. Nahan. Now we would like to turn to the procedure foundation of this code, and I would like to invite Mr. Hamidi to have your insights on the main highlights of this criminal procedure code. How does it compare to the previous Afghanistan's criminal procedure code, and what does this code really mean for individuals in courts in Afghanistan, and where are its most serious procedural gaps in this code? Mr. Hamidi, the floor is yours, so you can speak in your preferred language. I think you would like to speak in Dari. So for our audience, as my colleague said, there is the translation option, so you can choose from the Zoom screen. Thank you very much.
تشکر از شما دکتر صاحب. سلام علیکم و رحمت الله و برکاته. به نام خدا بسیار تشکر میکنم از شما و همکارانتان به خاطر که به وقت و زمان مناسب این وبینار ترتیب کردین و اساتید بسیار محترم و صاحب نظرهای بسیار محترم در اینجا شرکت دارن. صحبتهای بسیار خوب را شما کردین و وزیر صاحب نهان کردن. در رابطه با کود جدید یا طرز العمل یا اصولنامه جزایی طالبان برای محاکمشان صحبتهای بسیار زیاد صورت گرفته. در این رابطه متاسفانه برخلاف سنت قانونگذاری در افغانستان، ارزش‌های ملی و در عین زمان ارزش‌های دینی مردم افغانستان، این کد جزایی در تناقض آشکار با تمامی ارزش‌ها قرار دارد و به خصوص در عصری که ما زندگی میکنیم، در دورانی که زندگی میکنیم و افغانستان تقریبا در بین همسایه‌های خود یا در منطقه‌ای که قرار داره نسبت به هر کشور دیگه بیشترین اسناد بین المللی حقوق بشری را الحاق کرده و یک عضو مؤثر و فعال اسناد بین المللی حقوق بشر بوده که این کد در تناقض آشکار یا در ضدیت آشکار با تعهدات دولت افغانستان برنامه که در گذشته بوده به هر ترتیب افغانستان عضویت اینا را داشته و هنوز دولت افغانستان به عنوان یک استیت، به عنوان یک دولت مکلف به رعایت اونمو تعهدات است که برای جامعه بین‌المللی کرده و در این زمان در مقابل مردم افغانستان مسئول و پاسخگو است. باید حقوق و تساوی مردم افغانستان را رعایت کنه که متاسفانه این کد یا این اصولنامه را که اینا ساختن در تناقض آشکار با تمامی رویه ها قرار داره. حداقل بعد از کسب استقلال سیاسی توسط شاه امان الله غازی و ایجاد اولین نظامنامه اساسی در افغانستان چند اصل ایجاد شد که از او جمله یکی تساوی افراد در برابر قانون بود، مسئولیت از شکنجه بود، لغو بردهداری یا امو عرف بردهداری که در افغانستان طی صدها سال وجود داشت. افغانستان از اولین کشورها بود در براعظم آسیا و اولین کشور بود در بین کشورهای اسلامی که قانون بردگیره و یا اصول و روابط و مناسبات بردگیره در افغانستان لغو قرار داد. حالان که جامعه ملل او زمان تقریبا 8 سال بعد از فرمان لغو بردگی در افغانستان در سطح بین المللی کنوانسیون منع بردگی را اعلام کردند. یعنی افغانستان از جمله کشورهای پیشتاز بوده برای تساوی حقوقی افراد در برابر قانون، مسئولیت از شکنجه و در عین زمان تحفظ آزادی، عزت و کرامت افراد. اگر این را ما مقایسه کنیم با قوانین قبلی افغانستان، به خصوص کود جزای افغانستان که در سال 2017 توشیح شد، افغانستان برخلاف ادعاهای طالبان و حامیانشان که دولت افغانستان یک دولت سکولار میگفتن، ماده دوم قانون اساسی افغانستان دین دولت افغانستان دین مقدس اسلام گفته ماده سوم قانون اساسی افغانستان گفته بود که در افغانستان هیچ قانون نمیتواند در مغایرت با احکام دین مقدس اسلام ساخته شود. ماده 7 قانون اساسی افغانستان گفته بود که دولت افغانستان منشور ملل متحد را، اعلامیه جهانی حقوق بشر و سایر اسناد بین المللی حقوق بشر که افغانستان به اونا الحاق کرده، اینا را مورد رعایت قرار میده. تقریبا از ماده دوم تا ماده هفتم دولت جمهوری اسلامی افغانستان با توجه به اعتقادات مردم افغانستان که دین مقدس اسلام بوده، در عین زمان رعایت حقوق افراد، آزادی‌های حقوق افراد که ناشی می‌شد از قوانین اساسی افغانستان و اعلامیه جهانی حقوق بشر و اسناد بین‌المللی حقوق بشر ساخته بود یک پیوند بسیار نزدیک و عمیق بین دین مقدس اسلام و یک دولت مدرن بین المللی و پاسخگو که به اسناد بین المللی هم الحاق داشت، یک رابطه بسیار نزدیک و عمیق را ایجاد کرده بود. دولت افغانستان برخلاف ادعایی که صورت میگیره یک دولت سکولار نبود. ماده دوم میگه که دین دولت افغانستان دین مقدس اسلام بود. به همین ترتیب کد جزایی افغانستان که در ماده دومش ذکر شده بود که این کد فقط جرایم تعزیری را پیش بینی میکنه، جرایم حدود، قصاص و دیت بر اساس فقه حنفی دین مقدس اسلام قابل تطبیق است در محاکم افغانستان. یعنی کد جزای افغانستان هم کاملا با استفاده از بهترین علما هم در داخل افغانستان، هم با مشوره با علمای بیرون افغانستان و هم با استفاده از تجارب افغانستان در طی قانونگذاری‌های مختلف که همیشه قوانین جزایی افغانستان مجازات تعزیری را پیش بینی میکرد، بنابراین اینا هیچ کدامشان با اعتقادات مردم افغانستان و با دین مقدس اسلام و در عین زمان با تعهدات بین‌المللی افغانستان در تناقض قرار نداشتند، بلکه کوشش صورت گرفته بود که به بهترین وجه و به وجه بسیار احسن عدالت و کرامت افراد مورد حمایت قرار بگیره، عدالت به بهترین وجه تطبیق شود، تساوی افراد در برابر قانون مورد رعایت و حمایت قرار بگیره. بنابراین اگر ما بخوایم این کد را با قوانین جزایی قبلی افغانستان مقایسه کنیم، این کد بر علیه کد جدیدی را که طالبا تصویب کردن و او را مریو الاجرا قرار دادن، در تناقض آشکار با روحیه و قلب دین مقدس اسلام قرار داره که اصل مساوات، اصل کرامت انسانی، اصل عدالت که جوهره و فضیلت اصلی دین مقدس اسلام است، کاملا در اینجا مورد تعرض قرار گرفته، مورد نقص قرار گرفته و در عین زمان با تعهدات بین‌المللی افغانستان هم متاسفانه که در تناقض آشکار قرار داره. در عین زمان خلاهای بسیار عمده که در این قانون وجود داره ای است که تناقضات بسیار زیاد در قانون جدید یا در این کد جدید وجود داره. از جمله اصول تفسیر قوانین جزایی در تمام جوامع بین المللی و حتی در خود فقه مذاهب مختلف اسلامی است که باید بسیار دقیق باشه، کلماتش بسیار سنجیده شده باشه و امکان تفسیر وسیع را نده. یعنی بسیار کمتر ای قابل تفسیر وسیع باشه، چون قوانین جزایی مستقیما با کرامت، با عزت، حیثیت، مال، جان افراد ارتباط داره. در این قانون اینا امکانات تفسیر بسیار وسیع ایجاد کردن. مثلا برای زندیق مجازات اعدام پیش بینی کرده، حالان که در مذاهب مختلف اسلامی برای زندیق یک تعریف بسیار دقیق وجود نداره. هر کسی را که بخواین اینا میتونن که اتهام زندیق را وارد کنن، چون اگر ما تاریخ اسلام هم ببینیم در حکومت‌های مختلف به خاطر زدن مخالفین خود تاپه زندیق را و به خاطر از اینکه خون از اونا را مباح بدانن و اونا را قابل اعدام بدانن، مخالفین خود از زندیق میگفتن. من نمیدانم که چگونه شما اینا میتونن زندیق را که در قوانین جزایی افغانستان به دلیل مبهم بودنش، به دلیل گنگ بودنش مورد استفاده قرار نمی گرفت، اینا به عنوان زندیق مورد مجازات اعدام قرار میتن. یا کسی که چشم نظر داره کسی را نظر میکنن. نمیدانم ایره چگونه میتونن اینا ثبوت کنن و کدام کریمنالیستیک یا کدام کریمنال تکنیک یا کدام اهل خبره یا کدام طب عدلی میتونه مشخص کنه که کی را نظر کرده و بازو کسی که نظر کرده چشم بد داشته او باید یک سال حبس را ببینه. به همین ترتیب سایه بالفساد در اینجا تفسیر بسیار کلان میتونن اینا بکنن و هر مخالف خوده که ولو یک انتقاد بسیار ساده هم کنه او را به عنوان سایه بالفساد هم خانهش آتش بزنن، تخریب کنن، هم خودش حقوقش و عزتش از بین ببرن. در این زمان تقسیم بندی افراد کاملا در تضاد با روحیه و اساس دین مقدس اسلام است. درست است که اینا این تقسیم بندی را از کتابای معتبر فقهی حنفی گرفتن، ولی او فقهایی که این تقسیم بندی را کردن محصول شرایط زمان خود بودن. در صدر اسلام ما این تقسیم بندی را نداریم. این تقسیم بندی ها تقریبا یا در فتاوای عالمگیریه که متأثر بوده از جامعه طبقاتی شده هند و یا هم توسط ابن عابدین و ابن تیمیه و یک تعداد از مفتیای دیگه یا مجتهدین دیگه وارد فقه شده که این کاملا تبعیض آشکار و بسیار سیستماتیک را در برابر مردم افغانستان ایجاد کرده. متاسفانه تنها این تقسیم بندی نیست که تبعیض ایجاد کرده، چند نوع تبعیض بسیار سیستماتیک و وحشتناک در اینجا وجود داره. یکی بین مسلمان و غیر مسلمان، دوم بین حنفی مذهب و سایر مذاهب موجود در افغانستان، سوم تقسیم بندی افراد به اشراف، به علما، به مقامات، به افراد پایین و افراد متوسط که این بسیار وحشتناک است و خلاف سنت های قانونگذاری و تساوی که هم در فرهنگ افغانستان بوده و هم در قوانین افغانستان بوده. اینا از جمله و در این زمان تبعیض سیستماتیک که بر علیه زنا وجود داشته، این قانون این تبعیض به صورت مضاعف آورده و مشکلات بسیار زیاد را میتونه برای آینده افغانستان ایجاد کنه. عدم تناسق بین جرم و جزا.
We'll come back to this. به خاطر که زمان مساوی داشته باشیم به همگی سپیکرها.
درست.
I would like to kindly ask you to wrap up here, please.
خب مسئله دیگه هم عدم تناسب جرم و جزا است. شما درست است که جنگاندن حیوانات یک عمل زشت و بد و ضد اجتماعی است، ولی برای جنگاندن دو بودنه و یا دو مرغ 6 ماه حبس است و برای زدن زن توسط زوج یا توسط شوهر او هم در صورتی که استخواناش بشکنه و زخم عمیق ایجاد شوه و کبودی در وجودش آشکار شوه، او 15 روز حبس داره. هیچ تناسب بین جرم و مجازات وجود نداره. و یک مسئله را که میخوایم در آخر بگوییم این است که از قبل طالبا به مراتب شدیدتر و به مراتب ضد عدالت و ضد حقوق بشر قوانین در ظرف 4.5 سال گذشته هم در محاکم خود تطبیق کردن به اساس حکم فتاوا، ولی این بار ایره خواستن که تدوین کنن و این هم تقریبا یک چشم زخم نشان دادن به جامعه بین المللی است که اینا 4.5 سال یا تقریبا 5 سال میشه که در برابر سیاست ها و اقدامات طالبا خاموش بودن و حالی قانون هم اینا ایجاد کردن تا نشان بدن که هیچ پروای در رابطه با نظم بین المللی و قوانین بین المللی و حقوق و آزادی های مردم افغانستان ندارن. تشکر از شما.
Thank you very much, Mr. Hamidi, for your clear overview and also the comparison of this code with the previous Criminal Code of Afghanistan, Islamic Republic of Afghanistan. Now, you have outlined how this procedure code shapes the justice, how it operates in Afghanistan nowadays. So the next question is how this code stands with the Islamic legal tradition. And with that, I would like to turn to Mr. Muhammad Tariq Osman, and I would like to have your opinion from Islamic classical jurisprudential perspective, that what does this criminal code realistically represent? Does it fit genuinely with doctrine of Islam, or it reinterprets Sharia in ways to expand the political authority in Afghanistan? So I would like to kindly ask all the speakers to keep within the allocated 5 to 6 minutes of time, so each speaker has the equal opportunity to speak. Thank you very much. Mr. Osman, it's your turn now.
Rahim. Thank you for offering me the time of 5 minutes. I hope I will be able to follow it. In regards to the Penal Code that is issued by the de facto administration of Kandahar, I will analyze it very shortly from three points of view. The first is the legitimacy of the de facto administration, which is under question because they are not coming based on the principle of governance in Islam, which are election and the bay'ah. That's the first point. With an illegitimate government, all the decrees and laws that they issue is under question. The second point is the authority over Sharia principles. Sharia principles are only for the God, which we call it in jurisprudence a Sharia. And the usul will come only from that source, not from ordinary people or even the king or rulers. For that reason, the usulnama, which we call it furu'nama, is so-called Amirul Mu'mineen approved it, which is not the authority to overpass the Sharia or God order. The third point is about the Penal Code. I will raise 5 issues in relation to this Penal Code. The first is contradiction with the explicit textual sources with verses of the Holy Quran in Nusus. I will provide one example for this. The Article 9 contradicts with the verses of chapter 4, verses 1, and chapter 4, verses 135, and chapter 49, verses 13, and chapter 5, verse 8. That's against these verses. In the same time, the other example is if there is double or half of the punishment than in the first century of Islam, that is to the wives of Prophet Muhammad, according to chapter 33, verse 30, they were said if you do something same, double punishment will come to you. But in the other context, for female slaves which would exist at that time, according to chapter 4, verses 25, half punishment was given. This is the real demand of the Sharia, not to give the elites less or no punishment, or give to the poor people any punishment that they want. The other point is internal contradiction. There are many other articles or the section of articles which are against the verses of Holy Quran or Hadith. The other point is the internal contradiction and improper fixing of ta'zir. For example, the ta'zir is not fixed in Islam because this is connected to the person and to the crime both. And the judge or imam has the right to make it softer or a little harder, not harder like a had. But here, what they did, they are fixing and limits punishment, which is not allowed in Islam. And the other point is that they set penalties for that, which is not allowed in Islam. For that reason, there are legal problems from Sharia perspective. The third one is self-refuting provision, the bid'ah. They call the bid'ah who is the mubtadi, who is not following the Ahl Sunnah wal Jama'ah. Actually, they are not following the Ahl Sunnah wal Jama'ah themselves, because they contradict the Amr vice and versa point in Islam, which they made a ministry for that, and they made a law for that. Both of them are bid'ah and not permitted in Islam to be done by the government. The other point that I want to go, that is this misuse, distortion, or misquotation of references. The references that they gave, either they didn't translate it well to Dari, or they didn't understand, or they added something which is not the reference in the source that they were referring to. The fifth point, which is the last point, the problem in the source they used in this penal code. And that is, mostly they use the 88 fatwas or fatawa books in 137 times citation of Hashia ibn Abidin. In fatwa is not that is context specific, time bound, advisory in nature, not universally binding legal rules. For that reason, getting order or ruling from fatwa is not valid from one time to another time. Ibn Abidin is not in the first level of Hanafi school of thought. He is called muqallid jurist or fuqaha muqallidin, which doesn't have the right to go and override the principle of Hanafi mazhab, which is done by that person. Because many of these things, I think, talking for hours and exploring how they overrided the Sharia and the principle of governance in Islam, it took many times, much times. We cannot do it. Still, I am 2 minutes over time. Thank you.
Please. Thank you very much. Thank you for your insights. So now from a doctrinal analysis, we want to move to see how this code operates within the family, particularly in relation to women and children, as our speakers also touched base on this. So I would like to invite Dr. Noor. Dr. Noor, as you read the Criminal Code of the Taliban, Article 32 limits accountability for domestic violence. Article 34 criminalizes women who repeatedly seek refuge within their families without the husband's permission. And Article 48 also allows fathers to punish children for missing prayers. From Islamic ethical perspective, does this legal structure protect family and its stability, or it turns guardianship into unchecked authority? So how should this provision be evaluated in light of Islam's principles of dignity and protection from harm? Over to you, Dr. Noor.
Thank you, Atifa. Assalamualaikum warahmatullahi wabarakatuh. I think this kind of legal structure risks turning guardianship into unchecked authority rather than protect family stability. If we want to evaluate in the light of Islam, we need to start from our belief that in Islam, every person has eternal status as a mere servant of Allah, which is Tawheed, and mandate as Khalifa fil ard to create common goodness or al-maslaha al-amma for fellow humans and even other creatures. This inherent status and mandate demonstrate that every person is full subject. No one is a secondary subject, let alone an object. And as a complete human being, which is not only a physical being, but also an intellectual being because of having intellect, and also as a spiritual being because of having intuition. This consciousness of humanity changed the relationship between husband and wife and between parents and children. Initially, women were treated as men's property, as sexual tools and reproductive machines to give birth to men's children in the time of revelation. Women were born as their father's property, married as their husband's property, and when a husband died, it was passed on to husband, children, and male relative. The basis of relationship between husband and wife and between parents and children is absolute ownership and power. The maslahah of life then are only for the father and husband when the children and wife have no right to the maslahah. Islam shifted the basis of ownership and absolute power to protection or wilayah and responsibility or qiwama. The father is no longer as the owner but the protector of the children, and the husband is the responsible person of the wife. But this is only an intermediate target of Islam because it still positions the father and husband as primary subject so that the maslahah of the children and wife is determined unilaterally by the father and husband. Since the Islamic missions of humanity is that every person is full subject and a complete human being, then parents and children as well as husband and wife supposed to protect each other and are mutually responsible for each other. This is what we call equal qiwamah and wilayah. The common maslahah, such as dignity and protection from harm, must include the maslahah of wife and children and from their perspective too. So any legal structure that permits single party to determine the common maslahah as the goal of Islamic Sharia risks into unchecked authority. I think that was my answer. Thank you.
Thank you very much for keeping the answer very short, but at the same time very comprehensive. And now I'd like to go to Mr. Mustafa Akil, that as you know, beyond the family life, this code also defines religious identity and diversity within Islam. And Article 2, Clause 8 defines followers of Hanafi school as Muslims and others as innovators, and also Article 26 criminalizing criminalizes leaving the Hanafi school, and also another article, Article 14, permits killing under public interest for those defending false belief. So what do you think? Does criminalizing diversity within Islam reflect broader Islamic intellectual transition, or it does transform religion into an instrument for political control? I'd like to invite your analysis, Mr. Akil. Thank you.
Assalamu alaikum, and peace be upon you all, and thank you very much. And thanks to Faragar for keeping up this important battle. When bad ideas are in power, preserving and voicing the good ideas are really crucial so that we can hope for a better future. Thank you for this question. Just 2 weeks ago at the Cato Institute, Washington, D.C., we just published this book, No Compulsion in Religion, No Exceptions. No compulsion in religion, or La ikraha fi din, is, of course, a verse from the Quran. But some certain Islamist movements don't want to implement it in full. They minimize the implementation of that verse. So that's why we emphasized this principle in the Quran. And there in the book, there's a line I myself wrote in the introduction. It says, religious coercion is always wrong for various reasons. One is that it oppresses even pious Muslims themselves, because whatever is enforced in a certain country is always a certain sect or interpretation of Islam at the expense of others. So we showed examples of, for example, some coercive Sunni states which discriminate against the Shiites, or discrimination against Sunnis in Iran, which is a Shiite state in its official ideology. And we called for a neutral, ideally neutral state. Now, Taliban has just given a perfect example of this problem, as you pointed out, by saying that Hanafism is the only allowed sect in Afghanistan. Of course, and that is their understanding of Hanafism, and Hanafism is a big spectrum. There are much more moderate interpretations of Hanafism in Central Asia, Turkey, where I come from, or in the Balkans. Taliban actually represents the most hardline version of that, and making that as the only allowed sect. This is, of course, oppressive, and it goes against actually the Islamic tradition. I mean, there are certain problems there, maybe in Islamic traditional approaches as well, but this goes beyond that. This goes actually against that, because we know throughout Islamic history and Islamic empires, beginning with the Umayyads, Abbasids, and later the Ottoman Empire, different schools of thought in Islam typically coexisted without some exceptions. Actually, there's a famous story that Imam Malik, one of the founders of the four Sunni schools of thought of jurisprudence, the Maliki jurisprudence, actually, he was asked by the early Abbasid rulers about making the Maliki school of jurisprudence the only accepted jurisprudence in the empire. And he said, no, we shouldn't do that. It would be unfair. So he allowed other schools to exist. He wanted to allow other schools to exist, and which they did. In the Ottoman Empire as well, Hanafism was the official sect, but people could be Shafi or Maliki in different territories, let alone Jews and Christians following their own traditions, until the Ottoman Empire went towards equal citizenship in the 19th century, which was another important step. So this is definitely a tyranny of one group over others. This is not even an Islamic state. This is a Taliban state, very narrow. Now, there's even more. I mean, in the Penal Code, which I went through last week, there's the criminalization of disrespect to scholars. In Article 17, it says, if a person deliberately and knowingly states words such as, I do not act in accordance with the juristic legal opinions of the scholars, respected scholars, or if he says the statements of the scholars are not acceptable, the judge shall sentence him to 2 years of imprisonment. So, and obviously those scholars are Taliban's own scholars. So you're not even allowed to say the statements by the Taliban scholars don't make sense to me. That puts you in jail. Whereas in Islamic tradition, we have a perspective of celebrating ikhtilaf, disagreement, in the community. So this goes beyond that as well. There are, of course, many other concerns. There's a law which criminalizes Muslims eating publicly during the month of Ramadan, in which we are now. Many Muslims, of course, fast, but it gives 20 lashes for somebody who eats, which, of course, brings the question, should people fast because they fear God and want to worship God? Or should people fast because they fear the Taliban's religion police? This actually interferes in the act of fasting, which should be based on piety, which should be based on willing worship. But it turns that into a government-imposed law. Another pretty concerning article that I saw is ta'zir for an apostate woman. Now, they go with the Hanafi view of not seeing apostasy of females, apostasy meaning change in religion, as a had crime. But what they bring there is, it says, the judge shall sentence an apostate woman, like a woman who lost her faith in Islam, who became Christian or maybe secular atheist. The judge will sentence this woman for the purpose of compelling to accept Islam to life imprisonment accompanied by 10 lashes every 3 days. Like imagine an Afghan woman loses her faith and respect to Islam, and the Taliban puts her in jail until she dies. And they lash her every 3 days so she can see the beauties of Islam and come back to the religion. I think this will only lead to more apostasy, more people losing their faith and respect to Islam, as it happened in Iran. I think what the Taliban is experimenting today is another version of the problematic structure we saw in the Islamic Republic of Iran. For 50 years almost by now, the Iranian state imposed its own understanding of Islam on society, forcing women to wear hijabs, punishing people for apostasy or other things, interfering in Ramadan. They ended up in not having a more pious society, but a much less pious society, in addition to all the human rights violations they have caused. So this is definitely, there are some clauses like banning theft or crimes, that's fine in every legal system, but these oppressive clauses in the Penal Code is very concerning. It will do huge damage in Afghanistan, harm a lot of innocent people, and ultimately harm Islam that the Taliban supposedly wants to preserve and promote.
Thank you, Mr. Akil. That brings us to the next issue, which is about the delegation of punishment by this code. It means the punishment is not now kept in the courts, or justice is not here anymore, but it is it's shifted to the hands of other people. So I would like to invite Dr. Ansari to answer one of related questions, which is the clause 6 of Article 4 permits any Muslims to punish a witness sin. So how does this article should be understood within the Islamic legal tradition? And also from your experience of working with OIC as a Muslim majority country organization, so why has this organization, OIC, has not taken any strong position about the situation, the legal developments in Afghanistan, especially this code, and what are the practical advocacy strategies that Afghan civil society can have to more engage or engage effectively with OIC? Floor is yours, Dr. Ansari.
والصلاة والسلام على رسول الله صلى الله عليه وسلم. In the name of Allah subhanahu wa ta'ala, the Lord of justice, freedom, and equality. First of all, I want to thank Faragir. I want to thank this organization from the bottom of my heart for organizing this timely webinar. And regarding the legislation, the new legislation of Taliban, the criminal code, I want to say that by this code, the Taliban have made our country a laughing stock of history in today's world. By this code, they turn the society into horn-knocking animal. So anyone can attack anyone in the society. By this code, they turn the society to a society who are engaged in war of all against all, according to Hobbes. By this code, any person can commit assault or aggression against someone doesn't in the society, and that person who was accusing, assaulting, he doesn't need a judge. He doesn't need a court procedure. He doesn't need prosecutor or any law enforcement. The only thing he needs, a big turban, a beard, a Kalashnikov, or a strong muscle to implement whatever he believes that it is right. So this code, the code of conduct, this clause is derived or deduced from the hadith that Abu Sa'id al-Khudri narrated in Sahih Muslim. من رأى منكم منكرا فليغيره بيده ومن لم يستطع فبلسانه ومن لم يستطع فبقلبه. Whoever sees wrongdoing in the society, he should change it by his hand. If he cannot, he is not available. He doesn't have ability. He should change it by his tongue. If he cannot, he should change it by his heart. What is the meaning of this hadith? The problem is the Taliban, they limited themselves in specific books. They read maybe, according to Nizami Nisab or curriculum, maybe 15, 20 books. And after that, they call themselves mufti or scholar. So if we go to the tafsir of Qurtubi, in the commentary of verse 21 of Surah Al-Imran, he says that enjoining good and forbidding evil by hand is the responsibility of a state, not of individual citizens. And what does good and bad means? It's not what Taliban believe. This is another issue. We can talk it in another session, maybe. Changing or preventing evil or preventing evil in the society by tongue, it is the responsibility of scholars. And enjoining in good and forbidding evil by heart, it is the responsibility of general public in the society. One of the commonalities between all legal systems in the world is that the authority of enforcing law rests in the hand of the state. Number two, any accused person is innocent until his guilt is proved by court. المتهم بريء حتى تثبت إدانته. To sum it up, any Talib can humiliate any citizen in the society. The scope of application of this code is too wide in the society. It can contain the entire society. And you can consider any idea like bid'ah, because it is not aligned with the ideology of Taliban. So based on that, you can take action and you punish and assault and insult any citizen in the society. The society turned in a jungle, governed by the law of the jungle. Regarding the other question, so how the OIC can play a role, actually we have two kinds of organizations, international organizations. One is intergovernmental organization, one is non-governmental organization, NGOs. The OIC, the Organization of Islamic Conference, is intergovernmental organization. As an NGO, civil society, we cannot influence this organization. We cannot do anything. Actually, I can say clearly that we cannot do anything. The only way is to approach some countries The only way is to approach some countries. In those countries, through their Minister of Foreign Affairs, can bring change. And every year, every single year, in summer, actually, maybe in July, August, from June to August, maybe, they have a conference by the name of CFM, Conference of Foreign Ministers. The 57 countries, they get together. And before that conference, they called the representatives of all member states to come to Jeddah and have consultation on the resolutions of OIC. That is the most important document of OIC, resolutions. What do? They come there, they consult, and after that they approve it, and they pass it to the organization of, to the Conference of Foreign Ministers, and they approve it there. So the resolution number 14 is about Afghanistan. So the only way, I think, is to get in touch with some country. For example, nowadays, Pakistan can be one candidate. Saudi Arabia is also not bad. We can approach it. And Egypt is also one of the countries that can help. So we have some countries in the world, we can approach them. And through those countries, the Ministry of Foreign Affairs of those countries can bring change. Even we can, the civil society of Afghanistan can approach the Ministry of Foreign Affairs of the State Department here in America, or Foreign Affairs, Ministry of Foreign Affairs of Canada, or some other European countries. And through those countries, they can deliver the message to OIC and bring the change. Jazakumullah khairan.
Thank you very much for your important insights, Dr. Ansari. We have another round of brief reflections on a broader implication of this code that I have question for all of the speakers, and I kindly ask you to keep within 2 minutes time frame to answer this question, which is what should international community understand now? What is the most topic about this, or the biggest concern about this code? And what is the one response that matters the most now? I would like to invite Dr. Noor to start with this first.
Okay, thank you. I realize that the global situation is not that good, and we may be pessimistic of the role of OIC, but I think we still need to build the solidarity between Muslim populated countries like Indonesia, Turkey, and others to give the attentions to the situation that happened in Afghanistan. And also the solidarity among international Muslim women, female Muslim women, women movement across countries and across religions. I think these two things that we may do at the moment, I think. Thank you.
Thank you so much. Mr. Akil, can you please touch based on this question? You're on mute.
Sorry, could you paraphrase the question? I didn't hear that one.
Yeah, what is the most important thing about this code that international community need to know, and what are the solutions? What do you suggest for Afghan civil society to effectively advocate for this?
I mean, this code definitely has terrible human rights violations that is built in. And what is interesting is that it even adds elements that are not in traditional Islamic law. I mean, medieval interpretations of Sharia Islamic law has some problems. So there are apostasy or blasphemy laws that needs to be discussed, and I discuss those in my work. But this law just goes further than that. For example, it divides society into 4 classes. This is not even in medieval Islamic law. I mean, it gives tazir. Tazir is widely used here. Tazir is the authority given to the Islamic ruler in traditional Islamic law. Here, it is used in a way that the upper class, Taliban itself, and their allies, are almost given very lenient treatment, whereas the lower classes are kind of treated with very harshly, prison sentences, lashes, but whereas if it's a scholar who commits the same crime, if it might not be a crime in the human rights sense, but they're just warned, whereas people are. So I think we need a 2-tier strategy here. Just Islamic scholars themselves, even traditionalist Islamic scholars, can come out and say certain things are not acceptable from an Islamic point of view. Like just imposing Hanafism in a Muslim society, banning other Islamic interpretations, calling others heresy. That is not allowed, right? I mean, you should allow different Islamic interpretations to exist, and that's been the Islamic norm for centuries. That's one thing. And then there are definitely modern. There are many clauses there that clash with the modern understanding of human rights, and there we need Islamic modernist interpretations or reformist interpretations there on the issue of apostasy, for example. There are some other Islamic states, so-called Islamic states, also impose these laws, but there are definitely reformist arguments against these. None of these have basis in the Quran. They come from medieval understandings where apostasy meant political treason or rebellion, violent rebellion to the society, whereas now people changing their political religious views out of their genuine convictions, that is not the same thing. So I think we need to do these things, because otherwise this will settle a very oppressive interpretation of Islam in Afghanistan as the norm, and it will have long-term terrible consequences for both the Afghan society and Islam as a religion in general. Taliban has become the icon of all the Islamophobes in the world. They point to the Taliban saying, this is Islam, that's why we have to ban it everywhere. That's why we have to expel Muslims in the West. So Taliban is also, by these laws, giving ammunition to all the hate preachers in the West who want to demonize Islam and all Muslims. That's another consequence of this really concerning situation in Afghanistan.
Thank you very much, Mr. Usman.
Thank you for your question. My answer to this question will be to promote Afghan scholars to counter this code and other laws that they enacted which are against the Islamic principles. That will be the best way. Wishing for other countries is not a very positive thing until we have the people of Afghanistan educated on what is the reality of Islamic ruling and principles. That will help. And promotion of that could be done through civil society in some supporting countries. And at the same time, those countries who were engaged in Doha, for example, Indonesia, Turkey, Pakistan, and Qatar itself, and even Norway, that they were there. They trained the Taliban on negotiation and different things they have good relation with. And Taliban were invited almost 3 to 4 times to Indonesia, and they have very close ties with those people. That's something can be pushed, but the first thing is to push internally and we have to bring the weaknesses of their penal codes and decrees, because from the August 21, they issued 258 law and decrees until now. That's they are all in one way or another way against Islamic principle and the rights Islam gave to any person. Thank you.
Thank you very much. Mr. Hamidi?
Thank you. I think the education of Afghans about these things is very important, and as Mr. Tariq mentioned, promoting the Afghan scholars and focusing on the agendas and policies of Taliban, which is against Islam and against Hanafi progressive fiqh. Also, if we just emphasize on international community, Taliban dividing the globe very simple by Dar al-Islam and Dar al-Kufr. Pressure from international organizations, especially the United Nations or like other Western countries, it will not have that much effect because it will unite Taliban and other people. They are thinking like Taliban because they're thinking this is coming from the Darul Harb. Not from Dar al-Islam. One of the issues that the Deoband ulama have a very vital role in India, in Pakistan, in Afghanistan, because most of the Taliban are following the Deobandi class or interpretation of Hanafi fiqh. I don't know how to bring the attention of the Deobandi scholars who are progressive, who are living in this time, this present time, not 5, 10 century back. The case of Afghanistan is already going on in ICJ. This new criminal code is also a systematic breach of CEDAW and other Afghanistan obligations to the international instruments. This one should add to the other accusations. ICC, there is cases of Afghanistan, and this criminal code is a systematic and widespread violation of all human rights instruments and ICC statute. This is another issue. Mobilizing Afghanistan NGOs, especially those NGOs working for human rights and human rights, documenting all the implementation or verdicts of the courts that are implementing this criminal code, case by case, especially against women. If you compare the number of women prisoners in Afghanistan, it is more than 1,200 now. Which is that the women, according to the policies of the Taliban, not allowed to go outside to education centers, to schools, to work outside. But the number, if you compare with the Republic time, it is 2 times more than the number of female prisoners. It shows that all these laws implementing on women, the Afghan civil society can document all these court's verdicts or court sentences against women and children. And I think all these cases are useful to the ICJ and ICC. But I am emphasizing on the education of Afghans about the issues of human rights, justice principles, and rule of law. That would be a good thing. Thank you.
Thank you. Thank you very much, Mr. Hamidi. Thank you for all of our speakers. We now turn to questions from participants. We'll take a few questions, and I would like to invite all the participants to ask their questions and write them in the chat box so we can read and review them accordingly and see which question is for which speaker. I think it's very late in Indonesia. Dr. Noor, it's midnight night there. Thank you for your time. But if you would like, it would be a pleasure having you for a couple of more minutes. So we'll see if there is any questions from our audience.
Ms. Taib, I think in the question box there are 4 questions. Maybe Ananya can read them, and then either all the speakers can respond to it, or whoever is feeling more relevant. Ananya, can you please read those questions?
Thank you.
Yes, I'll go ahead and read those questions. We have a question also in the chat box that came just now. So I think it's good to get started from there. So the question is from Masuma Khavari. She asks that I have a question about Taliban madrasas that have become centers for the cultivation of extremist ideas. Afghanistan will become an exporter of terrorism in the next 5 to 10 years. A generation will be raised that will affect Afghanistan, the region, and even the world in the next 50 years. Shouldn't we talk about Taliban madrasas as centers for the cultivation of extremism? This is open for all speakers if they would like to respond. Atifa Jan, do you want me to read all the questions at once or go question by question?
Yes. Please go through all the questions so that then the
Okay.
speakers can take note of them and then they can respond.
We have another question that came into the chat right now. How the Islamic scholar from Islamic countries can intervene and convince the Taliban to change their extremist views. I'll read out the questions from the Q&A bar. From Lee A. Do you agree that verse 135 of Surah Al-Nisa in the Holy Quran is evidence against the unfair and unequal penal code of the Taliban? And the second question is, why do you think there is support and sympathizing for the Taliban by certain groups around the world? For example, some Muslim media groups who claim they are oppressed in India or France or the West are now trying to justify and whitewash the crimes of the Taliban. I feel these people are weak and want to feel strong and independent against the West, but by their complicity and hypocrite support of the Taliban, they are defaming the religion and weakening their position. These are all the questions we have till now.
Thank you for reading out. Yeah, the floor is open to any of our speakers who would like to answer these questions or part of that.
And we can also request the speakers to have their final response as well here, because after this we have to wrap up the webinar.
Yeah.
So can we start from Hamidi side?
یک لحظه من ببخشید من فکر میکنم که در رابطه به سوالی که مطرح شد و در این زمان در فقه حنفی و در تمام مذاهب اهل سنت شما زمانی که ببینین نوشتن رد و نقد بر فتواها یک عمل بوده که از دوران تقریبا فقاهت که شروع شده تا به امروز جریان داره و یکی از خوبیای فقه اسلامی عمومی است که بسیار تکثرگرا است و در هر مورد چندین نظر وجود داره، چندین نظری که حتی به هیچ سرشی هم نمیشه که اینا را به هم آدم بچسبانه. این موارد مختلف خود نشان میده که جای برای بحث و جای برای نقد، جای برای رد کردن این فتاوا همیشه وجود داره. حتی امی اصولنامه که طالبا پاورقی گفتن و بسیار از رد المختار گرفتن، خویی در رد کتاب در المختار نوشته شده. به همین ترتیب شما در مسائل بسیار عادی فتوا که ببینید، حتی در مسائل جزایی، در فقه جزایی، حداقل در یک موضوع 6 فتوای بسیار متناقض و مختلف یکی دیگهشان وجود داره. بنابراین کشورهای اسلامی و علمای اسلامی میتونن که بر این اصولنامه رد نوشته کنن و هر ماده زیره مستند با احادیث و با آیات قرآن مجید و با تاریخ صدر اسلام که اصل مساوات و عدالت و برابری بین تمام انسان ها وجود داشت، میتونه که این یک مسئله بسیار مهم باشه. کتابای معتبر توسط مفتیای معتبر و توسط مجتهدین معتبر نوشته شوه و این رد صورت بگیره. یکی از راه ها میتونه که امی باشه به نظر من.
Thank you. Mr. Usman, Tariq Usman.
Thank you. I will respond to two questions. One is about اینجا یک سوال داری است فارقه های این اصولنامه را وضاحت بدهد که چطور میتوانند را با آیات معتبر رد کرد و طور مشخص شرح دهد که کدام آیات و کدام حدیث. خواهر محترمی خب بسیار زیاد وقت میگیره، ولی آیت هایی که ما در اینجا رفرنس دادیم در حساب ماده 9 که اونجا گفته شده که مردم به 4 طبقه تقسیم کرده، او به اساس آیت اول سوره نساء که گفته همگی از یک نفس و باز یک زن و مرد به وجود آمده، به این معنا که هیچ تفاوتی بینشان وجود نداره. و در این ما احادیث و آیات دیگه هم داریم که آیت 13 سوره حجرات از جمله از اون آیات ها است که به انسان ها ثابت میکنه که همگی یک نوع هستند و یک چیز هستند. قوم و قبیله به اساس بر تعارف ایجاد شده. کسی که بیشتر تقوا داره و بهتر است نزد الله. در پهلوی از او 2 آیت دیگه را که من رفرنس دادم، در اسلام اگر تفاوت در جزا آمده، اول خودش تفاوت وجود نداره، به خاطر که در آیت 135 سوره نساء اونجا میگه که یا ایها الذین آمنوا کونوا قوامین لله شهداء بالقسط. و در دیگه آیتش که آیت 8 سوره اعراف است، بله، در او میگه که یا ایها الذین آمنوا قوموا لله شهداء بالقسط. باز در آخر از اینا گفته میشه که ولو مردم بسیار قریب تان باشه شما عدل بکنین. اگر غنی و فقیر باشه، اگر قریب تان باشه، دوست تان باشه، باید شما از عدل کار بگیرین، یعنی بی‌عدالتی نکنین. به او خاطر طبقات دی آیات رد کرده. اما جایی که فرق آورده، مثلا به زنای پیامبر علیه السلام در آیت 30 سوره احزاب گفته شده که اگر شما گناه بکنین، فاحشه مبینه که معمول او را مفسرین زنا ترجمه کردن، به شما 2 چند جزا داده میشه، یعنی وضع 100 داره 200 داره. و ولی برای کنیزا که وقت وجود داشت، برای از اونا گفته که برای شما نصف جزا یعنی 50 داره داده میشه. که در آیت 25 سوره نساء هست. به این معنا اگر فرق میآید، خب باز به طبقه اشراف بیشتر است جزا نسبت به طبقه پایین. اگرچه فعلا هر دو امی طبقه وجود نداره در دنیا، نه کنیز وجود داره، نه غلام و نه هم ازواج مطهرات پیامبر علیه السلام. در دیگه حواشیش بسیار زیاد آیات ها است و حدیث است که حاشیه‌ای از این قانون رد میکنه و یا ایست که ضعف از او را نشان میده. یا ما گفتم که حتی اینا او را غلط ترجمه کردن وقتی در پشتو قانون نوشتن، بناهن شاید هم به 200-300 صفحه نوشتن ضرورت داشته باشه که ما یک 60-70 صفحه زیر برابر کردیم. Ma'am, they say about the madrasa of Taliban, I agree with our sister that these are the basis for expanding extremism and violent extremism in the world, in Afghanistan, in the region, also in the world. If this is not taken care now, it will be a big problem in next 10 or 15 years, or as our sister mentioned, in 50 years to the whole world. Because this careless action of the international community and other countries and Muslim countries caused this problem. If they didn't care now and they didn't pay attention to it, it will be very big in the future, because every bad and good things are copied by people. This group of extremists, mean Taliban, was copied to Pakistan now. It will go one by one to any countries, Muslim or non-Muslim countries. That's an alarm for the whole world, especially the Muslim countries and Muslims.
Thank you.
There are some way to do something about it, but it needs more discussion. Thank you.
Thank you very much, Mr. Akil.
Thank you. There was a question about Surah Al-Nisa, the 4th chapter of the Quran, and perspectives of women's rights there. Broadly on that, I can say rereading the Quran with a perspective of women's rights is a necessary work, and there are many scholars working on that. One is Asma Afsaruddin, my colleague, who has a chapter in this book. I would recommend people checking No Compulsion in Religion, No Exceptions, which is coming in translations in various languages as well. And she actually shows that the Quran came as a liberating force in history for women. And we generally, Muslims, take pride in that. We say, Quran gave women property rights at a time that they didn't have, or gave rights in inheritance at a time that most traditional systems did not give women those rights. And there are many verses in the Quran protecting women from abusive husbands. Now, one thing we should understand, though, is that if also the idea of women's rights further advanced in the modern world, and if we just stick to fatwas, legal opinions written about this, 1,000 norms of the scholars of the time, which we respect those scholars, but they lived at a different time. If we simply go and try to preserve what was there, we kind of turn things upside down. Islam, from a woman that liberates women or downtrodden, turns into a kind of oppressive system against women, and the Taliban does the most dramatic example of that. And it's terrible for women, it's terrible for society, it's terrible for Islam. Now, one thing I would remind again is, since the Taliban is Hanafi, claims to be Hanafi, they should look up to the Ottoman Empire, the Caliphate, on these issues. In the 19th century, the Ottoman Empire, the seat of the Sunni Caliphate, Islamic Caliphate, they realized many reforms for women's rights that included opening many modern schools so that women can be better educated. That included legal reforms for women, limiting polygamy, giving further rights in many of the issues like marriage, inheritance, and divorce. And these happened under Ottoman scholars, because those scholars understood that Western colonialism, Western imperialism is wrong, but sometimes Muslims conflate all modern human rights developments with that. No, there are some positive developments in the modern world today for more education for women, more rights for women, and I think we should connect them with Islamic values and norms and the Quran. And there are scholars who did that. There are scholars who still do that. And by refusing all of that and imposing a very archaic and rural understanding of Islam on all society, Taliban is harming the women of Afghanistan, the society of Afghanistan, and the religion of Islam. And that's why these efforts against that, like you do, are really precious. And thank you for doing it again.
Thank you very much, Dr. Ansari.
اول در رابطه با نقش علمای اسلام من فکر میکنم طالبان خود کریم آف د کراپ آف اسلامیک سیویلایزیشن حساب میکنن. دیگه اینا آمدن که دنیا را به طرف اسلام هدایت کنن، از گمراهی نجات بتن. اگر شیخ ازهر فعلا ببرن پیش طالبا شاید بگوین که چند دوره زده شود، چرا ریشش مطابق قوانین طالبا برابر نیست. و این خاطر منتفی از مسئله ای که علمای مسلمان نقش داشته باشن در این مسئله. یکی چند مسئله دیگر رو من بسیار سریع به او اشاره میکنم. طالبان در حقیقت یک نماد زیر پا کردن اعلامیه حقوق بشر هستند. حقوق بشر 30 ماده دارد. تقریبا تمام مواد حقوق بشر زیر پا شده و این قانون نو از یا تقریبا یک ماده که مانده بود که legalizing slavery، در این قانون یک قدم به طرف پیش به او است. مسئله دیگه ای که what Dr. Mustafa mentioned, so Taliban, if they are Hanafi, they should follow the experience, the history of Ottoman Empire. So you cannot rule today's societies with fiqh. It is impossible. So because of that, because in fiqh we have so many opinions, maybe 50 opinions on just one issue. So the judge can do whatever he wants because he can find a fatwa for whatever opinion he has, whatever decision he wants to make. Because of that, at the end of Ottoman Empire, they start legalization of fiqh. And Mujallat al-Ahkam al-Shar'iyya, the journal of Islamic ruling. So that's a very clear example for this. یک مسئله دیگه که بسیار مهم است مشروعیت دینی است. طالبان تا زمانی که من از مدت 20 سال صدا میکنم، شیق میزنم، تا زمانی که مشروعیت دینی را از دستی قاتلان نگرفته نشه، مشروعیت دینی هیچ کاری کرده نمیتونیم. مشروعیت دینی خطرناکترین سلاحی است که در دست طالب است، خطرناکترین سلاح که بالای سرمایه گذاری میکنه و اینسترومنتالایز میکنه دینه، یک ابزار میسازه. دیگه این مسائل است که میشه سرش فکر شد و ما باید که زیاد فوکس بین خود کنیم. گروه های کشور خود ما با هم جمع شویم، در دو دایرکشن باید کار شود، یکی دایرکشن داخلی، یکی هم بیرونی. اول باید با یک سلسله چیزای اتفاق کنیم در داخل خود، یک مکانیزم برش وضع کنیم و در قلب دو باز در تماس با کشورها و جامعه مدنی و با جهان آزاد شویم. تشکر.
Thank you. Thank you very much, all speakers, our participants. We have now reached the end of our webinar today. A special thanks to Faragir for organizing this important discussion, and again thank you all the participants. So today we have explored this criminal code through different lenses and themes. What became clear is that this is not simply a legal reform, it's a structural change and shift. The difference is now that before oppression was through different decrees, but now repression is built into legal procedure in Afghanistan. This code is not a legal document. It changes how power works in society, and it moves justice from courts into ideology and force. The legitimacy of the authority issuing this code is also under question, and without a proper legitimacy, how they can have such a code and punish people, which is again a questionable topic. Sharia belongs to Allah, and no ruler can approve, redefine, or control divine principles. And also there were many discussions about the tazir and how the faith is controlled and is forced, especially the woman's right, which is very deeply affected by this, and violation against women is and its consequences is very harsh to women in Afghanistan. So what should be done is, the takeaways that I have written down is that we need to educate people from inside Afghanistan about the real Islamic principles, about justice, about women's dignity, and about real Islam, what is Islam, talking about all these, and also clearly explaining the weaknesses and contradictions in this code with Islam. And another thing is that we can document the consequences of this code, if there are any cases, especially affecting women and children, and also engaging with Muslim majority countries. There were names of many countries, including Indonesia, Turkey, Qatar, Norway, and all ulama across the world. And also about the OIC, the focus was that we still can effectively engage with OIC, but the approach should be through the states, and also NGOs. The human rights NGOs can effectively work in this area, do the advocacy, and such programs like today's webinar is an important step towards discussing this code deeply, and also talking about its legitimacy within Islam, and also the international regulations. So thank you again for all of the speakers and audience. It's end of the webinar. I would like to say have a good day, but before that, if you have any points to raise, Ms. Nahan?
No, I'll come in to just say thank you everyone for joining here today. We have the webinar recorded, and the recording, along with a summary of the webinar, will be shared early next week. So we will be emailing it out to everybody who has registered, but you will also be able to see it on our website and on our YouTube channels. If you would like to get in touch with us, I have put our email address in the chat below, which says admin@faragir.org. That is from my side, Ms. Nehan.
Thank you very much. Already everything is very well covered by Ms. Taib. There are a few highlights that I would like to make as a way forward for us after this webinar. First of all, it was highlighted by all the distinguished speakers that the current code of criminal code is against the principles of Islam and against all human rights and international laws. And the second thing that was highlighted is the engagement of the Islamic scholars, something that we are very much committed to do and continue to do that. So we hope that you'll have a follow-up discussion with our distinguished speakers and discuss that how else, what other initiatives you can take to be able to follow up these discussions and to be able to build up on the recent initiatives that we have had. And we are committed to bridging the gap between them, the human rights and civil society of Afghanistan and Islamic scholars, not only from Afghanistan, but actually from across the globe, because this is such an important initiative, and we see that it's having consequences not only for Afghan people, but also for the whole world. Raising awareness, I will divide it into three categories. Raising awareness of the people of Afghanistan about their rights from Islamic perspective is so much important, because the lack of education is basically kind of forcing them to accept whatever is introduced to them in the name of Islam. So we have a much more harder job to raise as much awareness as we can, because to equip them with the knowledge to be able to raise their voice and defend their rights. And the second thing is the raising the awareness of the Islamic scholars. One thing that since 1 year that I have begun engaging with Islamic scholars, we have seen is that and they do care about Islam religion, of course, and they care about plight of people of Afghanistan. But the problem that we have seen is the lack of information. And until they don't have enough information, up-to-date information, it's difficult for them to engage and use their platforms to speak for the people of Afghanistan. So one thing that we are committed to do is to be able to provide more information through such platforms, engagements, and webinars and Zoom calls for the Islamic scholars around the globe, so that whoever choose to use use their platforms to speak about the people of Afghanistan, about the plight of Afghan women, about what Taliban doing in the name of religion. They have the information, they can do it. And the third part is the raising awareness of the international community. We already see the severe consequence of the situation of Afghanistan on the region. We see the situation deteriorating of security in Pakistan. We see the situation in Russia, that they just had a suicide blast. And then we see the situation in Bangladesh, where even the religious groups, they're also claiming and making recommendations like the Taliban. So we see those ones, and I think more discussing about those is helping us out to convince the states that they change their pragmatic and geopolitical and interest-based engagement with Taliban to a more principled engagement with the Taliban. And the last point is joining forces for advocacy. We think that by working together with Islamic scholars, we are complementing each other's work. We are supporting each other, and we can actually continue to do advocacy with the international organizations, with the UN agencies, with the state members, and keep on raising their awareness about the situation of Afghanistan to be able to convince them for the shift of policy. So the last point that I would like to make is that we are totally committed to continue building up on this, and we are going to soon approach all of you, the distinguished speakers, and a number of other Islamic scholars that we are in contact with them. And we hope to have a call with all of you and to be able to craft a pathway forward on how, like, pragmatically, and like what initiatives we can take to be able to continue making a progress towards some of the points that all of you have made. Thank you very much.
Thank you,
Thank you.
everyone. Have a good
Thank you.
rest of
Thank
the
you.
day.
Wish you all a good day. Thank you.
God
Thank you.
Hafiz.